Thank you so much for being with us with Bar and Benches interview series, sir. Um, my first question is you withdrew your consent for being considered elevated to the High Court as a judge almost a year after you were recommended. Apart from the lapse of time, what were the other reasons for it?
Yeah, I withdrew, in fact, exactly a year after I was recommended and about 5 months after I was reiterated. Lapse of time, of course, is the literal reason, but underlying that is the treatment of a counsel who has been not just recommended but reiterated by the Collegium. And the fact that you are kept in limbo while other appointments are made. In my case, there were 2 batches of appointments that took place. One were 2 learned colleagues from the district judiciary who were recommended along with me. Then in the interregnum, there was another appointment that took place. So that gives you a certain message that the executive is averse to your ultimate appointment. And that basically presents you with a deadlock, which can, in cases like mine, where we are first generation lawyers with no real influence of sort, that deadlock can only really then be broken by me doing something. So it becomes a matter of moving on in life, a matter of your self-respect, a matter of how the bar is being treated at large, which, let me tell you, is an important part of my decision, because you must have frequently heard a complaint that members from the bar who are doing reasonably well don't accept judgeship. But here is a case where upon accepting the call to duty and being not just recommended but reiterated by the Collegium, which reiteration, as you know, in PLR project's case is time bound, 3 to 4 weeks. So in this paradigm, if still nothing is going to change, and you see other colleagues waiting in some cases for 2 years, 3 years, then it becomes more than just a function of time. It becomes your entire life, in a sense, that you are kept in no man's land. I don't have to tell you the sacrifices that go with accepting judgeship, not just when you're elevated, but even prior to that.
Yes, absolutely.
Right? The significant changes that take place. So, all told, it doesn't feel right. And it also tells you that if the Collegium's reiteration is not being adhered to by the executive, then how do you change that deadlock? And honestly, after deeply thinking about it, I figured the only way to change or break that deadlock was for me to withdraw honorably and move on. And that's where the decision came from.
So over the years, you have been a very vocal critic of government's policies, whether it's AFSPA or the Citizenship Amendment Act. Do you think you voicing your opinions on these subjects prompted the central government to delay your elevation?
Look, for starters, I don't think you can call me as a very stringent critic of this government's policies, in the sense that AFSPA has been there before this government as well. And I don't recall making public comments on the AFSPA in any case. As far as the CAA is concerned, yes, I did certainly speak about it from a constitutional position. But equally so did I about the EWS policy of this government, which I have publicly said is constitutionally kosher. So these are not criticisms of a government per se. I am not a political person, nor am I an activist. So my take on a particular matter is really legal. It obviously in these cases has a social overlap. And therefore, I would want to correct that perception that I've been some sort of critic of the government. I've not. I've had a position constitutionally on policies both ways. Whether that has impacted the outcome, I don't know, because nobody tells you officially where you stand. Look, the government's involvement really is prior to your recommendation. As you know, it goes through many rounds. And thereafter, there is a second stage where even upon recommendation, the government has a right to send the file back. It's a right. I concede it, that the government has that right. At those stages, at the first stage, obviously, when my recommendation went through, I would think that ultimately the government had no difficulty. Otherwise, I wouldn't have been recommended at all.
Right.
Secondly, as to why the file was returned, I don't know. Those reasons are never really communicated to us. So this brings me back to my earlier answer that it's more a sort of a waiting game and a guessing game, right? Is it because of something I've said about CA? I don't know. I mean, the grapevine sometimes says it is, but there is no way for me to confirm it. That's really something that the executive can only answer.
Okay. So did you try reaching out to the Collegium after you withdrew consent? Was there any communication post the submission of your withdrawal of the consent?
No, of course, I did not reach out. I mean, in what capacity would I reach out to the Collegium? To me, this is a sacrosanct and a very professional process where things should happen the way they are supposed to. My reaching out to the Collegium was only in terms of writing to the Collegium, headed by the Chief Justice, informing them of my decision to withdraw. Thereafter, most certainly, I have not reached out to anyone and I have not received any communication from the Collegium in response to that either.
Okay. So do you think the time has come for the Collegium to once again publicly reveal the reasons why a particular candidate is not being considered for appointment? In the interest of transparency.
Look, if you're speaking with reference to my case, the Collegium did consider and recommend and reiterate. So that question doesn't arise. Those reasons are for the government to communicate, right? It's for the government to communicate and for the Collegium to consider which stage is passed. Now, beyond that, I think it's a slightly delicate issue because those reasons shouldn't then lead to washing of dirty linen in public. There are careers and reputations at stake. And we've seen in cases where the reasons given by the executive to not appoint, right, or to return a file can swing between good reasons to some absolutely unsustainable ones. But releasing them to the public, I'm not so sure what purpose that serves. I think certainly the individuals concerned have a right to know, right? But beyond that, I don't think so.
It should not be in the public domain, you mean to say?
I don't think so. I don't think so.
So the existing system of appointments provides no recourse in cases where the government does not process a reiteration. How can this and other flaws of this entire system be redressed?
Actually, the judgment in PLR projects is binding. It's law. And it clearly says that upon a reiteration, the appointment should take place within 3 to 4 weeks. Right? And you would think that the government would adhere to that. And it has been fairly unprecedented that reiterations have also not been acted upon. So in cases where people are aggrieved, they do have recourse. In fact, the Bar Association in Karnataka filed a contempt petition in the Supreme Court alleging that the non-appointment of about 8 or 9 candidates pan-India was in contempt of the directions of the Supreme Court. Obviously, I would not go down that route because according to me, an appointment to the bench ought not to take place through a litigation itself.
Yes.
Right? We're not government servants. And I want to make that crystal clear that we are counsels who've accepted a call, right? We're not going to go to court. At least I'm not personally going to go to court on it. But if somebody chose to and wanted to, I would think they do have an actionable right. Now that contempt petition, in fact, I'm told has not been listed before the Supreme Court since its filing sometime in September. I could be wrong, but that's the intimation I have. So one doesn't know how the Supreme Court will view it on the judicial side. But it is still already a question that is pending in that proceeding.
So does the role of the Intelligence Bureau in the appointment process need to come under the scanner?
In what sense?
The inputs that the IB usually places regarding a judge's character, integrity?
Look, under a scanner is a strong thing to say because most certainly I believe that the executive should have a say in the appointments. It's not that the Collegium alone can unilaterally appoint. So if that means at the pre-recommendation stage, the executive through its intelligence agencies want to gather information and place a report before the Collegium, I would think any government is entitled to that, right? And if it's looked at in that sense, then the role of the IB is valid. Now, beyond that, whether it has to come under a scanner depends on whether that role has been used or abused from time to time. I'm giving you my example that my IB clearance would have obviously taken place even before the recommendation. Right? And there was nothing at that stage that should have come in the way. Right? Otherwise, my recommendation and the reiteration would not have happened.
Right.
So I do think that the role of the IB is important at that stage. Whether the Collegium feels historically, and that's not something I can answer, but if the Collegium feels historically that those reports have been credible or not, depends on the Collegium itself. And if they want to respond to that, they must.
But a very interesting development happened in the Supreme Court, which I'm sure you're also aware of, that when the tribunal vacancies were being discussed, and the matter was before a bench of even Justice Suryakant was part of. I'm forgetting who was heading that bench as of now. But there were some pertinent discussions about the role of IB. So it was the Attorney General K.K. Venugopal said that after appointments were cleared, certain additional inputs were received from the IB in the PMO, and thereby the appointments were halted. So the court took strong objection to the fact and said that the IB reports have to come only to the judges, and the judges will take a call on it, not the PMO. So do you think that this is some kind of a starting position wherein the judges are thinking on this line that, even in the cases of appointment of judges, not tribunal judges, there may be a possibility that, the IB reports or additional reports are being placed before the executive after the recommendation process is over?
No, it's possible that is a way with the
maybe
court.
Just not coming out in the public domain because there is no hearing on this taking place.
It's possible. And look, if there is subsequent material that for some reason was not available earlier, I will go a step further and still give that leeway to the executive and say, look, you've discovered something which genuinely comes in the way of somebody's appointment which the Collegium has missed. I would even give that one avenue to them. But my point is, A, that should come to the Collegium, as you said. B, once the Collegium reviews it and makes a reiteration, then I would think it's a fait accompli. And that's the law. Otherwise, it's an endless process, right? And there has to be credibility also with this process.
So are we saying that the hands of the Supreme Court is completely tied when the executive doesn't act upon reiterations?
I don't think their hands are tied. I mean, look, we're speaking of the Collegium of perhaps the most powerful court in the world.
Yeah.
Right? Have we not been led to believe that? So it would be a difficult position to accept that their hands are tied. I don't think their hands are tied. And I've seen the Collegium and the Supreme Court most certainly act when it wants to. In my case, unfortunately, after my reiteration, there was no movement from any quarter. Right? And which is why I said, if two strong and constitutional bodies are deadlocked in that sense, right, or parliamentary bodies or the executive, however you want to look at it, are deadlocked in that sense, then how do you shift things? But I will certainly not in principle go so far as to say that the Collegium's hands are tied. Of course not. It has its role administratively in the matter of appointment. It has its role constitutionally in that regard after the judgments in Scora and so on. And it also has its judicial power. I mean, what is the reason that in PLR projects, the court felt it necessary to lay down those directions by way of a judgment? There's a reason for it, yes. Right? After the NJSC was struck down, one looked at a new and an evolving Collegium. A lot of things happened on the administrative side. Perhaps the court felt that was not enough. Right. And which is why you crystallized it.
The PLR projects was also reiterated in Mahanadi Coalfields by Chief Justice of India S.A. Bobde-led bench.
That's right.
Before he demitted office. So I think that also showed how important the PLR project's judgment was.
And more importantly, I think rather than take this down the route of judicial directions, contempt, adversarial litigation, I do believe that in matters of constitutional appointment to constitutional posts, I think tradition is also extremely important. Precedent is important, right? I don't mean judicial precedent. I mean precedent in the way you act. We have believed that reiterations were final. Many governments have delayed appointments. We know that during emergency and later there were chief justices passed over, judges resigned, Justice Khanna resigned. That's not new to our system. But equally, I think we reached a stage where we believed that reiterations at least were final and then appointments would take place. But it seems that's not the case again. And that is where this new state of flux is difficult, I think, for the system. It leaves too many things up in the air. And in some sense, people like us, as I said earlier, first generation counsel, I think we in some way then possibly become the collateral.
So investigative agencies like the CBI and the Enforcement Directorate have been time and again criticized for being partial towards the current dispensation or targeting the opposition leaders. I'm sure you also handle a lot of cases in which such subjects are involved. What do you think? How can their independence be ensured? I know this is a very repeated question, but is there any...
Look, I think by and large, a lot of this comes down to the individuals heading these offices. The question of independence is not just one of the CBI or the ED. The larger question is the independence of the judiciary as well, isn't it?
Right.
We speak of that as part of the basic structure. And how is that independence ultimately to be achieved? Ultimately, pragmatically, I think it comes down to people discharging their duties neutrally, politically neutrally, standing true to the Constitution and to their conscience. This may sound like a slightly philosophical answer, but honestly, in my years of practice and study of cases, of institutions, my PhD was on a comparative analogy of democracy in India and Pakistan, so I've looked at it academically also. I believe beyond a point, there's only that much that law, regulation, stricture can do.
Okay.
Powers are there. You have the Prakash Singh judgment for autonomy of the police, right? What's happened? That judgment has been in force for 20 years. Have you reached a stage
There has been IAs filed in the Prakash Singh judgment time and again, and orders have been passed subsequently in those IAs, and still...
That's right. And states have taken a different position.
But so, I have a cross question. I have something to ask you, that when you are saying that it's about an individual's conscience and, how fair they are, is it easier said than done? Because if you are heading the CBI or ED, to what extent can you be at loggerheads with the ruling regime?
See, that's the point. Do you see it as being at loggerheads with the regime, or do you see it as you basically discharging your duty and standing true to your oath? And this is not a new problem. Historically, you have enough illustrations of officers heading many of these outfits who've done the right thing, right? And this I'm saying without pointing fingers at any particular government.
Some of the names that come to your mind, sir?
Well, look at Mr. Seshan, for example, in the Election Commission, right? Or look at people like Mr. Chandy, who was the Commissioner of Police here. Prakash Singh himself, right? But I would also look at names of judges who've done the right thing, right? Yes, in many cases, we found that they've had to pay a price. But then why are they celebrated today? Why do you look at Justice H.R. Khanna, for example? Or why do you look at Justice Jayant Patel, who, by the way, was the senior most Pune judge in the Karnataka High Court, was passed over for Chief Justiceship and put in his papers that very afternoon, right? Why do we look at those names for having done the right thing, right? You do it exactly because they stood tall. So is it easy? No, I'm sure it's not easy. But I think it's tougher to do the wrong thing. It's tougher to not stand true to the constitutional oath. I think larger questions arise. How do people see the role that you're discharging? Right? How do you want history to remember you?
Right.
How do you want what example are you setting to your peers and your juniors? I mean, if you're saying this is par for the course, then in that case, it's notional power, right? That's not power in the true sense, because power minus accountability minus neutrality is not power then. Then you're basically acting at the behest of the establishment. And most certainly that's not what the CBI or the ED or the intelligence agencies, or that's not what the judiciary are there for, because it can have a larger debilitating effect on our democracy. I don't want to digress into those conversations, but none of these things that take place are in a vacuum. They spill over. And they spill over, I believe, ultimately to the faith of the people, right? I have to return to the legal system because I know best about it. Where is the strength of the Indian legal system ultimately? Ultimately, it's in the faith, right? Of the litigant, of the citizen, of people who talk about the law. That's where the strength is. And if that begins to dissipate, as it is, right, that can be pretty serious, right? It can, in some circumstances, even be irreversible, and you don't want to go down that line.
Absolutely.
Yeah.
Subscribe to our YouTube channel and click the bell icon.